This is the Injury Pros Podcast, a serious and engaging look at how injuries impact us, the professionals behind it, and the strength it takes to represent the injured. We break down litigation strategy, medical expertise, real-life questions and stories, and the evolving landscape of where our industry is headed next. The Injury Pros starts now. Welcome to the podcast, Steve Medina.
Thanks, Mike. Good to be here.
So Steve is a New Jersey and surrounding states medical malpractice lawyer, right?
That's correct.
And you started the firm Medina Morgan?
I did.
And we had Cindy Morgan on earlier.
Yeah, thank you for that. I was able to listen to Cindy's podcast. I thought she was great, and I thought you guys had a wonderful conversation. I learned a lot. I'm sure it was helpful to your audience as well.
Yeah, so Cindy was talking about institutional sexual abuse cases, and that's a big thing your firm handles.
Yes.
And you also handle other civil rights cases, right?
We do. Yep.
And you also handle medical malpractice cases.
Yeah.
Which we're going to focus our time on today. So before we start that, can you tell our audience just a little bit about yourself?
Sure. So as you mentioned, I'm a partner at Medina Morgan. We are a newer firm. Before that, I was at a large national plaintiff's practice out of Wilmington, Delaware. I'm barred in Pennsylvania and New Jersey. I focus on medical malpractice cases, just anything with like an institutional injury aspect of it. So we do the institutional abuse work, we do civil rights work, we do some mass tort work, but my focus is primarily medical malpractice. And although I live in southern New Jersey now, I'm originally from Queens, New York.
Okay. And your practice is located in Philadelphia, right?
Correct. Yeah, we're right downtown at 18th and Market.
Okay. So when you just mentioned civil rights work, just for our audience, what do you mean by civil rights work?
So typically we do police misconduct work, vehicle pursuits gone wrong, excessive force, and then deaths and serious injuries in custody.
Okay. And what kind of custody?
Usually pretrial detainees, but if the case is right, if the facts support someone that's serving a sentence, then we can do that as well.
Gotcha. So like police misconduct, like you said, misconduct in prisons, things like that.
Correct.
When someone is in custody, meaning they're in custody because they got arrested or something like that.
Exactly. Yeah.
Yeah. Okay. Great. So you're from New Jersey. Did you grow up in New Jersey?
So from New York City, actually. So from Queens, New York, moved to the Philadelphia area for law school.
Okay.
And met a wonderful woman from Lancaster, Pennsylvania in law school. We got married, and Lancaster was too small of a town for a guy from Queens, and New York City was too big of a city for a girl from Lancaster, so we settled in the Philadelphia area, and we ultimately ended up in southern New Jersey.
Gotcha. So what law school did you go to?
Went to Temple.
Temple, okay. All right. And you worked for one law firm most of your career so far?
No, I've worked for a couple of large law firms. I started out doing plaintiff's work at a small firm in Philadelphia, then went to a insurance defense practice and did professional liability defense, so medical malpractice defense, and went to a litigation boutique doing both plaintiffs and defense work, and then ultimately, before Medina Morgan, ended up at a large national plaintiff's practice.
Gotcha. All right. That sounds like a lot of good experience on both sides.
Yeah. I mean, my career, path I always had an eye towards entrepreneurship, and I just wanted to develop my practice along the way, taking on more and more complex cases. And then when I felt I was ready, I had a good partner in Cindy. Seemed like the right time to start our own practice.
Gotcha. So we're here to talk today about medical malpractice.
Yes.
And I know from at least our firm, we get a lot of calls for medical malpractice, but the amount of cases that we can actually take or refer out that actually get pursued is a very small percentage, right?
That's true. And that's true for us. Our firm gets a lot of calls about medical malpractice as well. We have to carefully evaluate them. We, as medical malpractice attorneys, have a pretty good sense of, whether something looks like a case at the outset or not, but it's always a difficult analysis. And most cases are, most cases that come into our office are ultimately ones we will decline, but certainly there's many that we accept as well.
Okay, so for our audience out there, if you have a family member or yourself that you feel was mistreated by a doctor or a hospital or so. That happens all the time, right?
It does. And I mean, that's a big part of, many of the calls we get, right, is just poor bedside manner, a lack of attention to a patient. People feel as though their family member, their loved one isn't getting the attention that they would expect. And while that can be a factor in a medical malpractice case, it's often not a dispositive issue. I wish poor bedside manner alone was a basis for a successful medical malpractice claim, but there's usually a little bit more to it than that.
Yeah, and sometimes like people call, they have a bad result, whether it's a surgery or some kind of other procedure. And just because there's a bad result, obviously they're upset. And that oftentimes will prompt them to call an attorney, right?
Yes. And that's a good call to make, right? There's no harm in having a free consultation with a plaintiff's lawyer, whether it's for a car accident, a civil rights case, or for medical malpractice. We're a low volume, high touch practice. We're designed and set up so that when you call, you will quickly speak with an attorney, and we'll start the process of, evaluating your claim. And we'll do that by sort of talking through what happened with you as one of the first steps in that process. And I think that is oftentimes very helpful to our prospective clients. Even if they don't ultimately end up becoming a client, it can be very helpful for the purposes of closure to understand what happened and why this may or may not be a case.
So you're willing to talk to prospective clients for free, evaluating whether it's a case that you could take or not. And if it's not a case, you'll tell them why. And it may not be a case for your firm. It may be a case for another firm, but you're going to tell them why you feel that way so that they understand how the medicine works with the law, right?
That is one of the crucial parts of the investigative process for medical malpractice cases. And it's a big part of our practice. And we are happy to have those conversations, on a daily basis.
So those are, even when I was a younger lawyer, they're very complicated cases from the way I saw it. You may see it differently because you're a very experienced medical malpractice lawyer, but, you have to find who's at fault, right? Why it happened. Was it clear that the doctor or the medical provider was at fault? And then you have to have some serious damages or injuries that are more likely permanent in nature to be able to kind of justify bringing a case. Is that true?
I think that is generally true. From a complexity standpoint, right, the medicine is always pretty complex, and that remains true even to a lawyer like me, right? We always involve experts early in the investigative process. But from a technical standpoint, as a lawyer, the litigation follows a pretty traditional flow, right? Investigation. You initiate litigation if there's no possibility of pretrial resolution or pre-litigation resolution. And then you do your discovery, you serve your expert reports, you go to a mediation or you go to a trial, or both. So it's not uncommon. It's not very different from an auto accident case in that regard. We just have to work closely with experts to understand the medicine at issue, because every case is a little bit different in terms of the injury, the mechanism of injury, and the medicine and science involved.
And there's often thousands of pages of medical records that you have to review, right?
There are, and that's again one of the first steps if we think there's a case is to obtain those medical records, and that process is attorney driven at first, but then experts become involved, at least at our firm, very early on in the process, right? Because while we have a pretty good sense that we can assess medical records as lay people, not medical professionals, we still like to have the doctors or expert explain the nuance of what we're seeing in the record.
That's why I said it was kind of complicated, because you need to know some medicine. I know you're not a medical expert yourself, are you? In the term of like what we would use in court.
Right.
But you are kind of a medical expert because you need to know enough about a certain condition, a certain injury, a certain surgery, right? Certain medicines, to be able to even go down that route of a full investigation, right?
I think so. But, I look at it, I was thinking on my way in today, like if you asked me what one of the, key components of a medical malpractice claim is, right? You haven't asked that question yet, but I think this question kind of touches on that. And what I think is, I often think about opportunity, right? So when I look at records, I look for opportunity to make a different treatment decision, opportunity to intervene sooner, opportunity to recognize, a brewing infection, for example, right, that is oftentimes treated too late. So that is something that when you review medical records like we do on a daily basis, you begin to notice those opportunities to go a different route. And if you can recognize that, then you stand a real chance of sort of understanding what the claim potentially is and having an informed discussion with an expert that gets you from point A of just, is this a claim, to point B, it is a claim and we're going to pursue it.
Gotcha. So, when you get calls from potential clients, is there a similar set of facts that you hear a lot where people think there may be a medical malpractice claim, where in fact it's pretty clear based on the cases and the history of the law? For example, you mentioned infection. Is there any types of those cases that are clearly not cases because they're, for example, a risk of something, risk of surgery, risk of this, risk of that, that maybe the client signed off for? What can you tell our audience about, general claims that are not, general ideas that are not really medical malpractice claims that can go anywhere?
Yeah, it's a nuanced question because, oftentimes we will see patients with an unfortunate outcome. And if it is a risk of procedure, right, something that they signed off on going into the operation, as this could be the bad outcome, sometimes it is just the unfortunate luck of the draw, right? So we are cognizant anytime someone comes in and says, I had an emergent procedure and something bad happened as a result of that procedure. We know that that doesn't mean it's a case, right? But we, again, look for the opportunity we look for an opportunity to say, okay, was there a different route that could have been charted here, right? For example, were all the correct decisions made during the procedure, right? Was the post-operative care managed appropriately? And if it had been, could it have prevented that bad outcome? So we look at, when we look at a procedure gone wrong case, we're not just assessing whether this is a, risk of procedure. We're also assessing, what happened before, during, and after, and opportunities for a different outcome.
Gotcha. So we often hear infection is, for example, a risk of every surgery because the doctor's cutting someone open.
Right.
And that's kind of true, right? But from what I get from what you're saying is that, when you cut somebody open, well, if you knew you were going to cut somebody open, maybe you should have cleaned the area before properly. Maybe you should have, applied some antibiotics first in a certain procedure. Then there's the surgery, and then that was done, right? Hopefully that was sealed up and, bandaged clean. But then, like you said, the post-operative care, could they have prevented the spread of that infection, or did it get worse because of things they did or did not do?
Yeah. We'll often see cases where there are clear signs of an infection post-operatively, elevated white blood counts, a trend of rising white blood cell counts, right? And then the question becomes, should you switch over to an antibiotic that might cover possible infections better than what the patient is currently on, if anything? And that sort of decision can mean the difference between life and death. I mean, that happens routinely in my cases where, an infection, the warning signs of that infection are not picked up on soon enough. And because of, an easy decision to initiate antibiotics, that if it's not made timely, then you can see a terrible outcome. So that's the kind of...
So those are still cases then? Infection cases?
Oh, sure. Yeah, I would say that a big part of our practice deals with, poor management of infections, either post-operatively or just during the course of a hospitalization. That can be a very viable claim.
So before a potential client or a family member calls your office, what should they do to prepare for that call with you? Should they document? Should they get medical records ahead of time? Should they document the dates and times of communications? What would you suggest that somebody who's looking for a lawyer like yourself, how would they be prepared for the first call with you?
I think one of the best things you can do is just have a sense as to if your medical records are available to you, and if they are, get them as soon as possible through a patient portal, right? When you call us with a potential medical malpractice case, chances are you have a pretty good sense of where the malpractice occurred, the dates of the malpractice, who the doctor and hospital are, right? Or else you wouldn't be calling us. But you might not know that most of your records are available through patient portals these days, right? And you should download those records as soon as you can, especially if you're calling on behalf of a family member who is very ill, someone who might pass away, or someone who just did pass away, because those records will be inaccessible to you when someone is deceased, right? Or can't log on to obtain the records for themselves. And if they're inaccessible to you, then that means we have to likely raise an estate, right? And obtain them that way.
That way. Okay. So if the person's still living and still available, shall we say, is it your general suggestion that they get their own records first so that your firm doesn't have to request them, so that the medical facility doesn't think something's wrong?
It's not a question of putting, of raising the medical facility's guard. I'm not terribly worried about that. What I am concerned about for the benefit of our clients is quick evaluation, right? And while we will always request medical records as a part of our ordinary investigative process and get the medical records directly from the provider, because oftentimes they'll look a little different than what the patient is able to obtain, I still think it's very helpful in the evaluation process if the patient goes onto a portal and downloads their records.
The initial evaluation, right?
Yeah, correct.
Then once you agree as a law firm to pursue the case, you'll sign what's called a contingency fee agreement. Is that how that works?
It is how it works. Just like I think your practice, Mike, our clients don't pay us unless and until there is a recovery.
And I think New Jersey's law is a little different than Pennsylvania's in that department, right?
So New Jersey is set by statute as to the fees lawyers can recover, and the way those fees are calculated is a little bit different, but it is very much the same process. We will present the client, if we're going to take on a case or even investigate a case and we need to act on the client's behalf, we will send a contingent fee agreement, and we will, the language in that fee agreement will be set, by the states we're working in, the jurisdictions we're working in. So the New Jersey retainer looks a little different than the Pennsylvania retainer. The terms are slightly different, but ultimately the process is very similar, and we're able to quickly get those retainers out to clients when the need arises.
Gotcha. So client signs a retainer, and your firm opens a file, right?
Correct.
And then what is your process like once you start really taking on the case and really digging into it? And do you send out more medical requests? Do you do some research? You mentioned experts you hire?
Yep. So the way our practice is set up, we're able to easily consult with experts. We have essentially what you would call a stable of experts, and if we need to bring someone new in a different specialty, we're able to do that very quickly. First steps are probably to roundtable the case with the attorneys in the office, talk about the pros and cons of the case, talk about what records we may need, right, just for the initial evaluation, and make sure we have those records. So if we have to go out and obtain records, we'll do that. But once we feel like we have a sufficient amount of records to present the case to an expert, then we like to do that as soon as possible, because these investigations, they can move quickly when you have what you need, but there can always be unexpected bumps in the investigative process. And so you want to act as promptly as you can. You want to keep the client regularly updated. And if you're able to finish your investigation sooner rather than later, you should do that, because, the process of getting the case from intake to litigation can be longer than your traditional personal injury case.
Sure. So initial call, you do some initial kind of evaluation. If you agree to take the case, you take the case. Then once you take the case, you sign the agreement, then it sounds like you get into some real investigation here. You get more medical records, you hire an expert or assign it to an expert that works with your firm, and then they're going to do their evaluation and then report back to you about what they found, right?
Correct. And usually, if we've gotten to that point, we have a pretty good sense that the expert will come back favorable to us. But if they don't, right, we never want anyone to, be anything other than honest with their expert opinions, right? Because, that's what you need. You need a credible expert when you're litigating a case. Then we'll oftentimes take it to a second expert for a second look, because opinions do vary, and someone might not see the case the same way that, one doctor may see it differently than another doctor. So we're oftentimes, if we really are believers in the case and we think it's a strong case, which is pretty much every case that we accept, then we're going to at least put that case through one or two looks before we make a final decision that it's a no. And if it's a yes on the first go around, then all the better. We can start drafting a complaint. We can decide whether it's appropriate to discuss early resolution with the hospital or doctor, and then, move forward from there.
Gotcha. So your experts are important in medical malpractice. You actually have to have them to pursue the case, right?
You do. That's something that I do talk to my clients about, because, often the question comes, well, why can't we just file suit, right? Like if I believe it's a case, if you believe it seems like a case, why can't we just file suit? When you are litigating a medical malpractice case, the law is such that courts, state legislatures, they want to discourage what they would call, non-meritorious or frivolous claims, right? So in Pennsylvania, as an example, there is a certificate of merit requirement. And the certificate of merit requirement states that I, the lawyer, have consulted with an expert, and that expert has provided a written statement to me saying that the care at issue was below the standard of care. In New Jersey, you have what's called an affidavit of merit, which is actually an affidavit from the expert saying, essentially, this is who I am, and I also have found that there is a likelihood that this case evidences a deviation from the standard of care.
Gotcha. So experts are super important, but their opinions and how they get to those opinions are super important, because you have to, like you said, stand by them. You have to prosecute your whole case and move forward on that expert's opinion. So you have to be able to test that expert's opinion. You have to know the pros and cons and the strength of that expert's opinion, because his or her opinion is going to make or break your case, basically.
Yeah.
Even if you make it all the way to trial, that's the person who's going to be on the stand being subject to cross-examination, that the jury is going to look at and listen to, and ultimately have to believe that expert's theory, right, to be able to win the case.
Yeah, and of course, just like in any personal injury case that involves expert testimony, that the other side will have experts too. So they will have someone who takes a different viewpoint than your expert. So you need to have a credible expert, as we were talking about, right? And that credibility extends to making sure, like on our end, that the person hasn't been inconsistent in the past, right? So we want an expert that hasn't said, the care here fell below the standard of care, but then on a very similar fact pattern in another case, they were serving for a defense attorney and said, same facts, but there was no deviation.
That's interesting, and that's a problem in every type of case for both sides, right?
Yeah.
How do you determine whether what they said in the past, is that an easy task to do, or is that something that's more difficult and you really have to have a hard conversation with the expert?
Well, I think it's part of the conversation with the experts, typically not a hard part of the conversation. They're, they're able to fairly easily say, no, I haven't testified to anything like this in the past. But we usually go a step further, right? We have the capability to do sort of a sweep of the expert's past reports, trial testimony, right?
Okay.
To make sure that we can sort of vet that conversation.
I guess that's a lot easier today with AI. You can actually look at these reports, a massive amount of reports or data, and actually that could help you go through those records, right?
Yeah, I mean, we consider ourselves a tech-forward firm, right? We like to leverage technology in any way we can. AI is a part of that. Ultimately, at our firm, an attorney's always going to have the final eyes on something, right? And we actually, to do that sort of sweep and gather that information, we don't use AI. We will work with consultants to get past trial testimony and reports. But yeah, if we're, anything we can do to streamline the process, as long as it doesn't take away from the attorney's judgment, that's a good thing.
Gotcha. So one thing that we see a lot in our practice, whether it's an injury case or a med mal case, we have a lot of older clients, right?
Yeah.
And clients in their 70s and 80s and high 80s at times. And unfortunately, some of these clients may be in nursing homes,
right,
things like that. Is there a cutoff where you would take a case based on age because maybe that person doesn't have much time left, or is that looked at a different angle, for example, that they only have a little bit of time left and that time's precious? How's your firm evaluate that?
Yeah, I don't think I know we don't have a cutoff, right? I have clients right now in their mid 80s. I think that's as high as I go at the moment. I evaluate each case on its own merits. And so I would never discourage someone, from calling about their 90-year-old relative that passed away, right? We're going to look at the damages. We're going to look at the care at issue. We're going to look at the conduct of the doctors. And if we think it's a case and we think we can help you, then we'll help you.
I think you're also going to look at the plaintiff or the injured person's story, right?
Yeah.
How did they get there? What was their life like before that? And how fast did it turn for the negative?
Right. A perfect example. I'm thinking of an 85-year-old client that passed away, or a decedent that passed away. I represent the family, and that person was going every year on trips to Paris with their grandkids, and they were living a very rewarding life, still operating a business, right? So they were not your typical 85-year-old. And for me to just take a look at that case and say, because you're 85, I can't help you, I think would be an incredible disservice to the family. And it's just not the approach we take. Everything factors into our decision. So damages, age, we consider things like that, but that is a question of value as opposed to whether we're going to pursue the case. It's really a question of how much, not whether we will or won't.
Okay, so it sounds like there's no real limitations to you at least looking at the case and trying to decide, do we have an avenue here that we can really further investigate, sign the client up, and pursue? And then once our experts really dig into it, because they're the real people that give us the medicine behind it, because we're not medical doctors.
Right.
We know a lot about medicine. We're not medical doctors, and certainly we're not going to testify. They're going to testify. If they think it's a go, you're a go. If they think it's a no-go, you may get a second opinion. And if there's two no-goes, you might say, this is tough, right? And you give them the honest answer, right?
Yeah, I mean, we like I said at the beginning of our conversation, one of the big things we can do, even if we can't help you get a recovery, is provide closure, right? And clarity as to what happened. So if we look at a case 2 or 3 times and every time it comes back negative, you're going to hear from us exactly why this case was not something that we could help you with. We're still going to encourage you to get a second opinion from a different lawyer, right? And we'd be happy to even connect you with someone if we think there's someone well suited for the task. But our goal is to help in any way we can, right? And one of the ways we can help is give you closure, certainty about what happened. But I think if we're getting to that point where we're having experts look at the case, we're very hopeful that we're going to be able to get you some kind of recovery, some kind of justice from the legal system, as opposed to a declination.
Sure. And I feel that, when you have a loved one that you feel is mistreated and, you really care about that person, you're going to feel like a moral obligation as a family member to look into it, to do your due diligence, your dad or mom, and say, hey, I did my best. I consulted with Steve or this firm or that firm.
Right.
And we did everything we could to try to see if we had a claim here, to respect mom or dad and what he or she had went through. And if there is no real claim under the law, because the legal standard is different than what we think should happen,
right?
And you're going to tell that family member the truth. You're going to be straightforward, tell them what the expert says, and explain to them why your firm at least can't take the case. And at that point, you said you're going to, at the very least, maybe get a second opinion, because these opinions don't cost anything for the most part, right? They're just lawyers are generally give free evaluations of cases, free consultations. And, if that family member still wants to pursue it, which you would always recommend, because you're just one decision maker.
Correct.
And your firm is a small firm and you can't take every case.
Correct.
Where other firms may take more riskier cases on, meaning that there's not a lower chance of winning, just because they're a bigger firm. And that may or may not be good in the long run, because if you take a riskier chance on, there's a whole lot of emotions that go through that case, through litigation, through depositions, and then you get to a jury, especially in a rural town or something, where they don't really find often for medical malpractice plaintiffs. It's going to be a big disappointment at the end, and then nobody's going to be happy, right? So it's better to kind of give them your truth, tell them what it is, communicate to them, so at least they feel like they've been heard, so that they can move on and have some closure, right?
Yeah, I mean, I agree with everything you've said. I think that we try to start the change that our clients want to see. We try to be the first step in, that in them seeing that change, right? We, for example, I often say to my clients, if you leave your doctor's office, right, and you have a follow-up question, sometimes it's so hard to get an answer. Should I take my pill on an empty stomach, or should I take it with water, right? You have to go through an app to ask that question, and you get the response 24 hours later or something like that. Yeah. We don't want your experience with us to be that way. Okay. We want to be available to you essentially 24/7, even though we hope you don't call us into at 2 a.m, right? But we want to be at your disposal if you've signed up with us. We want your experience with your lawyers to be very different from your experience with your doctors. And we also, I just want to be clear, we will take on the hardest cases. As a small firm, we've set ourselves up so that we can punch above our weight, and we find often that we can take on cases that other lawyers maybe, for one reason or another, they don't think they can handle the case, right? They don't see a path forward. We've had good results with those types of cases. But that said, if I don't think it's a case that I can help with, you should absolutely seek a second opinion, because different lawyers have different opinions and they consult with different experts, and there still may be a path forward for you to get justice for yourself or that loved one.
Yeah, and I think it's our duty as lawyers to listen to the clients, do your investigation, and then explain to them if it's a case or not a case.
Yeah.
Because if it's not a case, they just need to know why. Because the legal system is mystifying to a lot of people, sometimes lawyers and judges, but the client who's inexperienced with the law needs to understand how the medicine and the law interact. And you just don't want to say, yes, I'll do it, and then create expectations later that they're going to be seriously disappointed.
Yeah.
And at the same time, if you're pursuing the case, you have to feel as a lawyer that you're going to have a very good chance of winning, because these cases take years oftentimes, right?
They do.
They assign the best and brightest defense attorneys to medical malpractice cases, because there's a lot of risk, right?
Yeah, sure. The exposure is catastrophic.
And the amount of money you have to pay on experts is significant, right? We're talking tens to hundreds of thousands of dollars at minimum for some of these cases, right?
Yeah, we usually think that we usually calculate at least 10% of what we think the value is will go towards experts. So if you're thinking that this case is worth $1 million, you probably have to consider that you'll need about $100,000 in experts to successfully pursue the case, right? That's a good rule of thumb. It's not a hard science. I've had $1 million cases that I've spent $16,000 on, and I've had $1 million cases that I've spent $250,000. It's very circumstance dependent, but they are expensive to litigate. They are fiercely litigated, and oftentimes they resolve in the courthouse steps. So you need to be prepared to go the distance. You need a law firm that's prepared to go to the distance. As a client, you need to understand the length of this process, the impact it'll have on, your life, right? You'll have to commit to certain things like a deposition, like attending a mediation, perhaps. So these are all considerations that we will walk you through as we talk about, the next steps. And I think, to your point about, sort of helping clients understand, it's so important, and I'm sure you feel the same way. It's so important to just communicate with your clients regularly, to keep them in the loop as to what's happening every next step. I find that the difficult conversations are easier to have if you are in regular communication with your clients. If they know you, they trust you, that is going to allow you to have, it's going to make your work as a lawyer easier, whether it's a routine conversation or a difficult conversation about, what should we accept as a settlement. It's just easier if you've been communicating regularly with your law firm, if they've been keeping you up to date.
Yeah, I mean, in my experience, I've always wanted to build trust with my client.
Yeah.
Right. Hopefully they came to me from a referral or somewhere online where they found trust, like through a review or something like that. But even from day one, they have to trust you as their attorney. And part of that trust is giving them straight information, being real with them, communicating with them regularly. If something comes in that's negative on the case, you got to tell them, right? It's not necessarily your fault it came in. It's just facts of the case, right? So if you build that trust and communication, generally my clients over the years have liked me. And when they like me and they trust me, they're going to be much easier to deal with in tough conversations like you just met. But then when it comes time to, okay, we have a settlement offer on the line. And what should I do, Mike? Should I take it? What do you think? And, I apply my almost 25 years of experience now and say, well, this is where I think they're going to go before litigation. This is where I think they're going to go with litigation. But we don't know for sure where they're going to go, right? Like it's not gambling as we go through litigation, but we don't hold the money. We don't hold the chips. We have to scare the defense so much, or their insurance company, that they're afraid to go to trial. Because if they go to trial, they could lose a lot more. So the more you show that you have a strong case, the more they may get worried and the risk factor goes up. So at that point, we hope we get better offers all the way to the courthouse, right? And sometimes they stick their head in the ground and they don't want to offer anything fair. And that makes it, for us lawyers, an easier trial because we know we're going to trial. But insurance companies are really good at giving just enough money where our clients are like, I got to think about this. Maybe I don't want to go through the stress of trial. Maybe I don't want to litigate. Right. Maybe I don't want my deposition taken because it's a really scary thing for most people. And their credibility is being tested, right? So insurance companies are really good at giving just enough for them to really think about it to make them go away and not paying the full enchilada. But other times they just don't like the case, or they pick this case to go to trial, and then we're going to trial. And at trial, anything can happen, right?
Yeah, absolutely. And we see in the medical malpractice space that for whatever reason, hospitals typically like to wait till the courthouse steps, right, to resolve a case. So you're going through the whole discovery process. I usually tell my clients to be prepared for that, right? That we're gonna fiercely litigate this case. We know that if we try to resolve it early, pre-litigation, we're going to get an offer that would be pennies on the dollar of what the claim is truly worth. We would recommend against that, and so we're prepared from day one to take the case to trial, right? You have to be if you're going to be in this space, or else I think you get picked apart.
Yeah. So in our cases in personal injury that we handle, we're definitely pushing a case to the end if we know there's a good injury and there's a lot of insurance coverage. And I assume you have the same thing in medical malpractice in almost every case, because you're not going to take it unless it's a significant injury, because there's a lot of costs and risks that go in there. And then I would hope that either the medical provider, the doctor, the hospital have enough layers of insurance that you don't have to worry about small policy, because usually smaller policies settle earlier. You won't have that problem. But I think in medical mal, and you can correct me if I'm wrong, you're generally going to have a lot of insurance coverage, and then you have an injury worth going after. So that's why, as plaintiff's attorneys, you want to push that as far as you can go, because the more you push, generally, closer to trial, the more the offer goes up, right?
Yeah, I mean, that's 100% true. There's always, in my experience, been adequate coverage. Very rare scenario where there isn't coverage. And Pennsylvania has an M-Care fund, which is a fund that will provide an initial layer of coverage for doctors, $500,000, and then beyond that, there's self-insured risk retention funds, there's excess coverage. So there is usually the ability for them to extend an offer that we would advise our clients to accept. I'm hesitant to ever say extend an offer, and I'm sure you feel the same way, but nothing makes you whole, right? So I never say they can extend an offer that makes you whole, because maybe you've lost a limb, maybe you've lost a loved one, maybe you've lost use of a body part, you're living in constant pain. No amount of money is ever going to make that right.
No.
But there's enough money for them to probably say, for you to say as a client, okay, we don't need to go through the risk of a trial. So the question is, how do you get there? And it's through diligence as an attorney, right? Just pursuing the case relentlessly, recognizing the defense attorneys are going to do what they do, which is, stall, right? They're happy to move at a snail's pace and watch the discovery period tick by, right? And end. We're going to move forward and push the case at every juncture.
Yeah, and going back to the trust between the attorney and the client, oftentimes we see clients want to give up. Even if we get to past depositions, say, for example, there might be $1 million on the table. You hope your client trusts you enough as an attorney to say, okay, I know there's more money there. We just had a recent case where the client probably would have settled for $1.5 million. And I said, hold on. I know there's more money. We have a really good case. Hold on. That's a lot of money for me. That's a lot of money. And I said, hold on, just give me another week. Give me another week. We're able to get almost over $3 million on that case just by pushing it closer to trial. And that client trusted me and had faith in me. And that was started from day one. And I hope every client is like that. But in reality is not every client is built to go through litigation. Just like a lot of lawyers aren't built for litigation, right? So it's stressful. It's time consuming. It's scary at times. It causes anxiety for clients and lawyers. But beyond that, that's the only way I feel in this business that you're going to get something closer to fair value.
Right.
Whatever that fair value really means, because there's no number on a body part or pain, right? It's whatever a jury of our peers puts on it. Whether that's fair or not, we never know.
Right.
So getting a real number that a client can live with and say, okay, this is done. I'm not going to take any more risk. I'm walking away. It may not be everything I wanted, but at least I can hang my hat and say I did the best I can, and I can live with this money, and it'll make life just a little bit more comfortable.
Yeah, I mean, that is, the same calculus that goes through our minds with these kinds of cases. And you'd like to have a client that trusts you like that. That's been my experience just through our practice of keeping people updated, explaining what's happening in their case, that we develop a real close relationship with our clients, a relationship of trust. And that's, very much by design. When you only have so many cases in your practice, because most of the cases are big and have catastrophic exposure for the defense, the defendants in the case, then, you're able to be that high touch practice that allows you to build that relationship.
Yeah. If you can get those cases, Steve, that's what I would suggest. Keep the numbers low, give great service.
Right.
And then you could push those cases farther. You don't have a normal lawyer doesn't have the bandwidth to push 100 cases all the way to the end. But if you're working on a smaller number, that client gets more attention, that case gets more attention, generally results in a better ending, right?
Yeah, and listen, there's different kinds of law firms out there, right? There are law firms that are set up for their lawyers to handle a high volume of cases. Maybe there are auto accidents or premises liability matters, right? And that's just the way the firm is set up. If you're in that sort of law firm and a catastrophic medical malpractice case comes into your door, in my opinion, and it's not just because people send me those kinds of cases from those types of firms, but my opinion is you're very well served by referring that case out. And the reason being is I just think that if you haven't done this kind of litigation before and you're going to slot that into your mix of 100 cases, you're going to find that it requires a completely different set of priorities. It's going to take up a disproportionate amount of your time, and it might just not be the best business decision. It might be a smarter decision to send it out to someone that does medical malpractice all the time and has built a firm that's designed to do that kind of case.
As a young lawyer, before I started handling some serious cases, catastrophic cases, I always looked to what's best for the client. Right. Even if I didn't make the same amount of fee as a lawyer, if I could pair up with a lawyer, kind of like what I did with my partner when I first started, who had years of experience over me, or I could work with him and learn the client's going to get much better value at the end. They're going to get much more money, and you're going to break out almost even. But you just learned as a younger lawyer or newer lawyer what it takes to handle a case like that. So I'm sure you're even willing to work with other lawyers that have cases to kind of work with you and bring them up, because you're always willing to give back. I know you.
Yeah, absolutely. I mean, you do know me. We love to, one of the things I really enjoy doing is teaching, right? I'm happy to share what I know about med mal cases or any area of our practice that we feel we're really strong in, right? Whether it's civil rights or institutional abuse that my partner handles a lot of. You know, we love to share what we know with the legal community in Philadelphia and the surrounding areas. There's no hiding the ball with us. I've built a career on being decent to other lawyers in the legal community, to my clients, serving them well, right? And I find that kind of openness, honesty, and good service, and just generally being a decent person, that gets you a lot further in this line of work than being someone who's, you know, known to be difficult to work with, or not someone that is, you know, a giver.
That's integrity. So Steve, as we wind down, thank you for coming on today. I think the audience has learned a lot. How can the audience, if someone has a medical malpractice claim, you know, reach out to you and your firm? Can you tell us how we can get in contact with you?
Sure. You can visit us at www.medinamorgan.com. You can email us at info@medinamorgan.com, or you can call us at 215-326-1717. Mike, it has been an absolute pleasure to be on your show. I know you to be a great lawyer and a person of integrity, and thanks for the opportunity to talk today.
We appreciate your sharing the kind of ins and outs of medical mal, and hopefully our audience has learned a lot.
It was my pleasure. Thank you, Mike.
Awesome. Nice to meet you.